Roy Cohn was a lawyer who treated every dispute as a knife-edge contest for dominance. Born in New York City in 1927, he rose to national prominence while still in his 20s as part of the prosecution team that secured the death sentences of Julius and Ethel Rosenberg for espionage. From that moment until his disbarment shortly before his death in 1986, Cohn cultivated a reputation as an advocate who would do anything to win. He considered civility a trap and saw litigation, politics, and the press as overlapping arenas in which raw aggression could bend outcomes. This essay explores the main elements of his combat toolkit, the social conditions that made them effective, and the long shadow they cast over American public life. An instinct for the preemptive strike. Cohn believed that the side which frames a conflict first enjoys a nearly unassailable advantage. Whenever he took a case, he moved with startling speed to file a complaint, summon reporters, and unleash language that portrayed his client as the true victim and the opponent as a menace to the community. Even if the factual record was thin, the initial blast fixed a dramatic storyline in the public mind. Opponents then faced an uphill struggle. Defending oneself against a vivid accusation is slower and more cumbersome than hurling it. Cohn refined this tactic during the Army McCarthy hearings in 1954, where he and Senator Joseph McCarthy accused civilian and military officials of harboring communists before those officials even knew they were under suspicion. Personalization of conflict. Where many lawyers argued in institutional or technical terms, Cohn zeroed in on individuals. Judges, prosecutors, witnesses, and sometimes jurors were portrayed as biased, incompetent, or morally corrupt. By shifting attention from legal merits to personal motives, he made every proceeding feel like a morality play in which his client was the lone righteous figure besieged by schemers. The strategy carried several benefits. It sowed fear in potential witnesses, who worried that they too might become public targets. It complicated judicial deliberation because any ruling against Cohn's position could be spun as proof of personal hostility rather than reasoned judgment. And it gratified his clients, who felt emotionally vindicated when he went after their antagonists by name. Manufacturing reputational costs. Cohn understood that most parties to a dispute value their public standing at least as much as any monetary or legal result. He therefore worked to raise the reputational stakes for adversaries. In business cases, he threatened to label executives as swindlers or anti-Semites, or, during the Cold War, as soft on communism. In criminal matters, he hinted that prosecutors were motivated by envy or by political ambition. And in the world of New York real estate, he signaled to rival developers that resistance would lead to headlines linking them to mobsters or slumlord practices. Because newspapers of the period were hungry for sensational copy, Cohn's warnings could not be taken lightly. One hostile article in a mass circulation tabloid could damage a brand for years. Exploiting procedural delay. At the same time that he launched early attacks, Cohn made liberal use of delay once the opening spectacle had secured an advantage. He filed a barrage of motions contesting jurisdiction, demanding voluminous discovery, or seeking endless pretrial conferences. Delay served two purposes. First, it drained the resources of opponents, many of whom did not possess his stamina for drawn-out litigation. Second, it allowed the media narrative he had created to settle into public consciousness while factual rebuttals languished in legal limbo. When an eventual trial arrived, potential jurors often carried months or years of one-sided reporting in their memories, making an impartial panel harder to assemble. Leveraging political connections. Cohn's godfather at his bar mitzvah was the powerful Democratic Party boss Abraham Rayfuss. His mother was active in New York political clubs, and his uncle served as a state senator. These early links blossomed into a lifelong network of politicians, judges, and regulators who owed favors or desired his protection. During the McCarthy era, he could summon senators for private meetings. Later, as a Manhattan attorney, he dined with police commissioners, borough presidents, and city council members. When legal hurdles threatened a client, Cohn often placed informal calls that reminded officials of past services rendered or future favors expected. Nothing he said was technically illegal, but the cumulative weight of reciprocal obligation tilted many small decisions in his direction. Zoning variances, trial scheduling, and even grand jury selections sometimes shifted subtly in ways that eased his path. Command of the media ecosystem. Cohn cultivated journalists with the same deliberation that other lawyers cultivated expert witnesses. He offered scoops, exclusive documents, and colorful quotes on the condition that coverage reflected his narrative. Reporters who complied gained timely access to courtroom filings and tips about new scandals. Those who did not could find themselves temporarily frozen out. The result was a symbiosis in which Cohn became a go-to source for sensational copy, while newspapers amplified his portrayals of events. He did not always need factual accuracy. By the time corrections or rebuttals appeared in later editions, the original framing had already traveled far on front pages and evening news broadcasts. Weaponizing ideological fear. The anti-communist panic of the early 1950s gave Cohn an emotional trigger that superseded ordinary evidentiary standards. Accusing someone of disloyalty carried such stigma that rebuttal scarcely mattered. Once that era faded, he adapted by exploiting new anxieties. During the 1970s, he invoked urban crime and union corruption. In the 1980s, he relied on public resentment toward government regulators. Whatever the cultural fear of the moment, Cohn located it and linked his opponents to it, often through insinuation more than proof. This chameleon-like use of ideological dread allowed him to retain the upper hand even as the national mood shifted. Refusal to concede or apologize. Perhaps the most distinctive feature of Cohn's method was his absolute commitment to never admit error. Even when evidence against his client mounted, he denied the premise, shifted blame, or launched a fresh counterattack. The tactic created a psychological dilemma for adversaries accustomed to incremental bargaining. Traditional negotiation presumes some willingness to cede ground. Cohn's rigidity rendered the usual give-and-take futile and forced opposing counsel to either push for total victory at great expense or accept the likelihood of protracted stalemate. Many opted for compromise on terms favorable to Cohn's side, simply to escape the quagmire. Mixing personal charm with menace. Accounts from colleagues agree that Cohn could be beguiling in private. He entertained lavishly, remembered birthdays, and offered networking favors without being asked. This charm was not separate from his combat strategy. It was integral. Friendly gestures lowered the guard of potential allies and convinced them that collaboration offered more reward than confrontation. When persuasion failed, however, the warm smile froze into a warning glare. Cohn signaled that anyone who crossed him would face unremitting hostility, both in court and in the press. The oscillation between generosity and threat kept interlocutors uncertain, a condition that favored his objectives. Strategic use of secrecy and rumor. While Cohn relished publicity, he was equally skilled at withholding information or circulating untraceable rumors when it suited him. He might hint to a reporter that sealed documents contained bombshell revelations, encouraging speculation that embarrassed the other side without providing verifiable material that could be disproved. In negotiations, he claimed insider knowledge of regulatory investigations or upcoming indictments, nudging opponents to settle before they could discover whether the warning was real. Even when later shown to be hollow, such rumors worked in the moment because they exploited humans' aversion to worst-case outcomes. Reliance on an inner circle of loyalists. Cohn surrounded himself with aides who shared his appetite for confrontation and his disdain for convention. They handled paperwork, monitored rivals, and delivered messages whose tone could vary from cordial request to veiled threat. The inner circle allowed Cohn to project influence simultaneously on multiple fronts. While he testified before a grand jury, assistants might meet reporters at a restaurant to leak selective excerpts of testimony, while yet another aide approached a city clerk to expedite a filing. The web of loyalists multiplied his presence far beyond what any single lawyer could personally oversee. Conditions that enabled effectiveness. Several historical and structural factors magnified the impact of Cohn's tactics. The first was the absence of robust professional discipline. Bar associations of mid-century New York seldom pursued ethics complaints with vigor, especially against attorneys tied to influential politicians. Second, media competition for readership rewarded sensationalism. Verifying claims risked losing a scoop to another outlet. Third, The Cold War environment imbued accusations of disloyalty with extraordinary power. Finally, many corporate and governmental institutions lacked sophisticated public relations machinery, leaving them slow to rebut Cohn's narratives. Limits and eventual downfall. Cohn's methods did not guarantee invincibility. Over time, his open contempt for procedural norms amassed grievances. In 1986, the Appellate Division of a New York Supreme Court disbarred him for misappropriating client funds, lying on a bar application, and intimidating witnesses. By then, he was also battling AIDS, a diagnosis he never publicly acknowledged. These converging pressures eroded his network and left him unable to deflect accountability as he once had. His fall illustrates that even the most formidable combat style can prove unsustainable when external conditions shift and personal liabilities accumulate. Legacy in law and politics. Yet the imprint of Cohn's approach persists. Students of political rhetoric note striking similarities between his playbook and the communication style later adopted by Donald Trump, one of Cohn's most famous clients. Rapid countersuits, relentless media warfare, and refusal to apologize became hallmarks of Trump's career in business and politics. Beyond any single disciple, Cohn's emphasis on framing, personal attack, and calculated delay has influenced lobbying firms, crisis management consultancies, and certain partisan media outlets. The result is an environment where victory often hinges less on evidentiary strength than on narrative aggression. Lessons for contemporary observers. Cohn's career offers several enduring lessons. First, speed matters. If you can define a controversy before your opponent gathers facts, you acquire a near monopoly on interpretation. Second, reputational battlefield extends far beyond courtroom walls. Third, procedural rules can be exploited as weapons by those willing to incur the collateral cost of delay. Fourth, a steadfast refusal to admit fault can be surprisingly effective when adversaries seek closure more urgently than vindication. Finally, reliance on fear-based messaging works only while audience anxieties align with that messaging. When the cultural tide turns, yesterday's fear loses force, and with it the efficacy of those who wielded it. Ethical and institutional countermeasures. The legal community has moved to curtail tactics pioneered by Cohn. Enhanced rules require greater disclosure during discovery, impose sanctions for frivolous filings, and mandate candor toward the tribunal. Journalistic standards have also tightened, at least in mainstream outlets, with fact-checking departments and corrections policies that weed out purely speculative claims. Yet gaps remain. Social media accelerates rumor in ways Cohn could only dream of, while partisan polarization revives the appetite for personal vilification. Institutions that wish to resist the next generation of Cohn-style combatants must invest in rapid response capacity, transparent processes, and public education that prizes evidence over theater. Conclusion. Roy Cohn saw the law not as a search for truth, but as a terrain on which the bold impose narratives and the timid suffer them. His combat strategies, preemptive attack, personalization, reputational pressure, procedural delay, media manipulation, and unyielding denial, were products of their time, yet adaptable enough to inspire imitators long after his own star faded. Understanding his playbook is essential for anyone who wishes to safeguard legal and political institutions from similar forms of predatory advocacy. The legacy of Roy Cohn is both a warning and a call to vigilance. Rules alone cannot contain a combatant who treats every rule as merely another weapon unless the broader culture demands integrity as fiercely as he demanded victory.